Good morning to our esteemed American audience and speakers, and good afternoon to our distinguished attendees joining us from Europe. I'm Adelina Zapis, Head of Network Development at WOLEP, and on behalf of the WOLEP team, I'd like to express my gratitude to each of you for taking the time to join us today. We are thrilled to see such a diverse audience. So welcome everyone to our highly anticipated webinar titled A Practitioner's Guide to American Whistleblowing Programs, led by our esteemed members and renowned American attorneys, Mr. Marc Raspanti and Mrs. Pamela Coyle Brecht, both partners at Pietragallo, Gordon, Alfano, Bosick, and Raspanti LLP, who will be guiding us today through the landscape of whistleblowing programs in the United States. So a special thank you to Marc and Pamela for leading the way in organizing this event. It is indeed an honor to have both of you with us today. Now I would like to hand over the floor to my colleague, Teodor Burna, Chief of Branding and Content at WOLEP, who will guide us through the agenda for this webinar. Teodor?
Thank you, Adelina. Good morning or good afternoon to everyone. Thank you for joining us. It's a pleasure to welcome our hosts for today and our speakers, Mr. Marc Raspanti and Mrs. Pamela Coyle Brecht. I will introduce them a bit and then I will hand over to them. Mr. Marc Raspanti is a highly respected lawyer, both in the state of Pennsylvania and the US. He has a wealth of experience, and by that I mean that he has more decades of working and excelling in the legal industry than I have of life. And he is a WOLEP expert in the very complex area of whistleblowing. 1 year ago, he delivered a very well-received presentation during a WOLEP webinar. He then focused on the US versus the EU whistleblowing programs and agencies and regulations. So welcome, Marc. It's a pleasure to have you again with us.
Thank you very much.
And I'll move on to Mrs. Pamela Coyle Brecht, our second speaker of the day. She's the colleague and the partner at the same law firm as Marc. And she's also a highly accomplished attorney at law in the field of whistleblowing and healthcare litigation, among others. We have profiled Pamela comprehensively during a previous WOLEP talk. It's a conversation which I encourage you to read, as it is very informative, both informative and inspirational. So welcome, Pamela. It's great to have you again on WOLEP.
Thank you, Theodore.
And before handing over to our speakers, I would also like to tell you a bit about our network. And for that, I will be sharing with you our presentation for the day. So as you probably know, our WOLEP Network, it's an acronym for World Online Lawyers with Excellent Practice, is an international community of lawyers which was established 2 years ago in 2021. We specialize in all areas of law practice, and you may have noticed recently that we opened 4 departments for professional groups in which we focus for the moment on corporate law, real estate law, sports law, and criminal law. And we are planning for the next years to expand on these practices. Our network's aims are to facilitate professional collaboration between lawyers in the network and to enhance their status on the global legal arena. Lawyers in the WOLEP network provide online legal consultations, either live or by drafting legal documents. And by cooperating, by collaborating, we are basically giving them a better chance of thriving in this very complicated economy. And I think Marc and Pamela would agree with me. So we are also providing them with opportunities for professional development and knowledge exchange, as is the case today. Members of our network have free access to PowerPoint presentations and other resources which are made available by our guest speakers, who are experts in various legal fields, and to WOLEP webinars recordings, which you can find on our YouTube channel. And now, without further ado, it's time to hand over the reins of this WOLEP webinar to our host speakers, while thanking each and every one of you for taking the time to be here with us today for this exciting event and topic. Enjoy this session. Marc, Pamela, please.
Thank you.
Thank you very much. So we decided to try something a little bit different with, now that we've gotten to know WOLEP, and we've also had the benefit of a bit of travel and a bit of interaction with many of our colleagues in foreign countries. And so our approach is designed for people who don't have the same type of experience. If you go to the next slide. And so that's just about our firm. We can go to the next one. So what we've learned is the American whistleblower phenomenon, if you will, is completely different from the rest of the world. And it wasn't until I started to write and lecture with other esteemed members in other parts of the world, in Italy and France and Germany and Japan, that I learned that our view of whistleblowing is frankly completely different, and maybe not accepted by many in the rest of the world, although begrudgingly some parts of our whistleblower laws are starting to be studied for a variety of reasons, including the anti-corruption laws that are being constantly updated in Europe. So we thought we would give you a perspective, and we've had discussions in which we frankly have some of our European colleagues couldn't believe that some of the laws were like this. And the more I've kind of studied internationally, it's very interesting to see the way whistle laws are coming about. But our whistleblower laws actually go back to the Middle Ages of England. And when there was no Department of Justice or no police departments or anything, the king would pass laws that would encourage people to come forward if they saw crimes against the crown, and to be rewarded for that. And so the first American whistleblower laws, and the first one passed, believe it or not, goes back to 1863, and President Abraham Lincoln, who at that time we were in the middle of a very bad civil war in the United States. And that was perhaps the first military buildup in the United States. In fact, we're sitting here in Philadelphia, Pam and I, and that's where many of the military establishment was located, that then spread out and took care of the Union forces at the time. So the decision was made that we needed to pass a False Claims Act statute, also known as a qui tam statute, which comes from the Latin derivative. And it really goes back to the Middle Ages of England. And qui tam is a shorter version of he who brings it, or she, on behalf of the king. And so that goes all the way back to the Middle Ages of England. And so Lincoln passed a statute, and the statute was designed to stop profiteering that was going on. As military buildup was occurring for the Civil War, Lincoln was finding out that like in every war, there were people that took advantage of the fact that there were a lot of money flowing in. And so there were cannonballs that didn't work. There were mules that died. There was food that was rancid. And so Lincoln decided, and he uttered the phrase, to catch a rogue, you need a rogue. And so he decided to incentivize whistleblowers who would come forward and tell the fledgling Department of Justice at the time and other people what to do if you needed to try and stop situations with fraud. That statute was in effect from 1863 until about 1943, where a series of amendments to the statute by the Supreme Court of the United States weakened the statute. And the statute pretty much died out from 1943 until 1986. And lo and behold, another president, President Ronald Reagan, with the support of a Republican senator and a Democratic congressman, maybe the last time there was support from both sides in America, decided to pass during another military buildup during the Cold War, and President Reagan was putting more money at the time into munitions, and therefore a new statute was born. And it's the new statute that Pam and I work on that came in 1986. And it's the statute that has been the most successful statute of, frankly, all statutes that exist in the United States when it comes to recovering money. That statute has then spawned a number of other statutes, which we're going to talk about today, which all have their origin in what I'll call the American Modern False Claims Act, 1986. It's also known as the Whistleblower Statute. It's also known as the Quitom Statute. So when we use those terms, they're interchangeable. So over the course of time, the federal statute passed by the American Congress did a number of things which we'll talk about that strengthened the weaknesses in the older statute and turned it into the mega statute that it currently is. And frankly, and if anybody on this conference can tell me of a statute that exists anywhere else in the world, please contact me, because I haven't been able to find it. But that's what happened. You'll start to get into where we are. So that statute dealt with federal funds. We also have 50 states, and those states passed 31 of those, well, 30 of those states passed. Washington, D.C. is not officially a state, but 30 of those states passed their own statutes, which goes after state funding. So if a state builds a road and there's corruption, or they build an airport and there's corruption, that's where that statute goes on. There's now in the United States, as a result of the 1986 amendments to the statute, and frankly, the amendments replaced the old statute. So while in the law books that refer to the amendments, as far as I'm concerned, it's a brand new statute. That has created an entire patchwork of prosecutors, agents, private lawyers who enforce the whistleblowers of the United States. Why? Because one of the unique provisions is the fact that private citizens, sometimes they're referred to as private attorney generals, can work with the federal government, with the United States of America, in order to recover false or fraudulent bills that were submitted to the United States. If you go to the next, slide, you'll see that as of the time I was preparing this slide, and that number has already gone up, $72.5 billion in recovery since 1986. No other statute on earth has ever recovered that much money. Now, this statistic, so it's clear, does not include the other whistleblower laws that we're going to talk about. It doesn't include a dollar from the 30 states that I just mentioned, all right? So if one just kind of takes that in for a moment, if you don't come away from anything else from our chat, $72.5 billion, wherever you're sitting in the world, is a lot of money. Let's go to the next slide. So what are some of the things that make this statute interesting or unique? I gave you a citation for anybody who wants to find it. in American law. Quitom, as I mentioned, is really synonymous with whistleblower, which is synonymous with another word known as relator. In the statute, you'll see relator because he or she relates. And the False Claims Act covers most federal fraud schemes, with the exception of certain schemes that happen in the United States military, certain schemes, and it exempts all IRS tax schemes. Okay, and we'll get to the reason for that, but there are only a few exemptions. Now let me get into what makes it unique in American jurisprudence. American law prides itself in being transparent. Therefore, whatever happens in our courts can be viewed online, can be viewed by the public with few exceptions. And for those criminal lawyers on the conference today, certain grand jury proceedings remain confidential. Certain other things are confidential, but 99% of everything is transparent. In American jurisprudence, the False Claims Act is unique because the complaint is filed by a relator, by a whistleblower, by their counsel, under seal, ex parte, meaning the other side does not know about it. So you literally can go to one of 93 federal courthouses somewhere in the United States. You can go, and Pam and I have done this many, many times. You show up at the door, you knock on the door, they take you to a sealed room, you file your complaint, and then you serve a copy of that complaint on the Attorney General of the United States and the sitting United States Attorney, which is the highest federal law enforcement person for that particular district. Unheard of in anything else we do. The defendant, the target of that whistleblower suit, doesn't know about it, maybe for a year, maybe for 2 years, while the government investigates. So that's an unusual part of the statute. The investigations are now conducted by many alphabets. I call them the alphabets, the FBI, Federal Bureau of Investigation, the HHS, which is Health and Human Services, which is in charge of protecting the gigantic Medicare program, all right, and the Medicaid program, the postal inspectors, the Defense Department inspector generals. The second largest amount of money in our country is spent either on healthcare or on the Department of Defense. So those two areas are where law enforcement now investigate those. If the government decides that the complaint that Pam and I filed, they didn't like it, it wasn't meritorious, they didn't have the right resources in place, they weren't ready to do it, and there's a million reasons why, whistleblowers have the right and the obligation under the statute, the way it was amended by President Reagan, to proceed on their own. And if they succeed on their own, they can recover up to 30% of whatever the claims were that are fined. So if it's $100 million and the government, which is always the party in interest, no matter who takes the case forward, the United States government under federal false claims gets $70 million. The whistleblower gets $30 million, all right? And there are other unique areas that Pam will get into in the next slide that when I debate my colleagues all over Europe, they can't believe. They need me to send them the statute because they can't believe that's actually a statute that would allow for that. So that is some of the backbone of a fairly complex statute. And Pam will get into some of the other issues that makes the False Claims Act rather unique.
So before I go to that seal that Marc talked about, the fact that the case is filed under seal and the defendant doesn't know it, there's actually a court order that puts that case under seal. And not only no one can talk about it, including the relator, which is very difficult. So you may be a relator or a whistleblower in a case that is under seal. We had a case that was under seal for 8 years. And so that seal applies to the relator themselves. Some relators don't even tell their spouses that they are whistleblowers or relators. And so who can be a whistleblower? Anyone can be a whistleblower. There is no requirement that you have worked for the defendant. You could be a contractor who has contact with the defendant. You could be a competitor, and more we are seeing in industries that are highly regulated, healthcare, defense, even shredding suppliers that shred, top secret documents for the government. All those competitors can be whistleblowers against their competitors, and oftentimes the argument is, well, this company or that company is getting a competitive advantage because they're committing fraud. And so anyone can be a whistleblower. It could be an individual. It could be a company. It could be, and oftentimes we have more than one whistleblower. We may have two people who are employees or who just know of each other. We had a lab case where we had an employee in a doctor's office and another woman who frankly met the first woman at church who did billing for the same doctor, who ended up being whistleblowers against the second largest laboratory company in America. So anyone can be a whistleblower from any walk of life. And you do not have to be a US citizen. So someone sitting in Romania or Germany or Italy or France or England or Bangladesh, for that matter, could be a whistleblower if they know about fraud being committed on the United States government.
Let me just interrupt my partner for 1 second. That provision, and I've been doing this work for 36 years, until 20 years ago, I didn't even know that provision was there. I assumed the statute was only for American citizens until a German citizen contacted me, and I went and looked at the statute, and I checked everybody, and I said, oh my God, you don't have to be an American citizen. So even I learned that through a very interesting situation. So anyway, I'm sorry, Pam.
That's okay. And while you do have to have what we call direct and independent knowledge of the fraud, you don't have to be a corporate insider. That's the point of the fact that competitors often are whistleblowers. But you must be first, meaning you have to be the first one to the courthouse alerting the government of a particular kind of fraud. And it used to be that if you were second filed, you could never have any recovery. That has been loosened a bit because the government has recognized that in these large national cases, oftentimes there are multiple relators who filed or whistleblowers who file in different parts of the country. And right now, the statute has been loosened a bit that you could still recover if you materially add to the information that the government has. And we've had ourselves had clients who were the third or fourth relator or whistleblower to file, and they have shared in the recovery. So, but that's sort of one of the things that makes our practice interesting, is if you're not first filed, how do you still navigate a very difficult system? And so the False Claims Act, or the whistleblower law, provides for robust relief, and the government can collect treble damages and civil monetary penalties. And to give you a brief illustration, there was a jury verdict against a group of folks who had also committed lab fraud. They were providing fraudulent genetic tests, and they were fraudulent because the lab had offered what you might think is shocking, $10 or $20 for every patient referred. Well, that ballooned all over the country into $1 billion fraud. And when those folks were brought to task, the subset of false claims underlying the jury verdict was $16 million in single damages. But with trebling and mandatory penalties, the judgment that was entered against those defendants exceeded $116 million. And so the robust relief that the government can obtain from the False Claims Act also makes it pretty unique. And a successful whistleblower can therefore receive pretty large awards, because if the government intervenes, meaning the government really takes the case over, the relief available starts at 15%, and the average of those intervene being about 18%. But if the government does not intervene and relators and their private counsel take the case over, the relator could get as much as 30% of the recovery. And the statute also allows for whistleblowers to collect their attorney's fees. So on top of the portion of the government settlement that a relator can get, the relator's attorneys can file a petition or resolve a claim for what we call statutory fees, the legal fees and costs expended in pursuing the case. And so another reason this is very unique in that in American jurisprudence, there is no right to collect attorney's fees from your opponent unless a statute specifically provides for that. And the False Claims Act.
I'm sorry, let me just add one thing, Pam, so because I think it's foreign to many people. In the early part of the False Claims Act, the first 10 or 15 years was directed almost entirely against the defense contracting fraud, military fraud. In fact, many people thought it was a military statute. The last 15 years or so have been healthcare fraud. And in our Medicare system, you may submit on a regular basis, let's take laboratories that Pam talked about, a small bill, 365 days a year, 24 hours a day for $180, let's say. Under the statute, that gets trebled, that $180 gets trebled, and then up to $15,000 in penalty for one claim. So that statute is pretty powerful and not like anything I've ever seen anywhere else. Sorry, Pam.
It's okay. Can we go to the next slide, please? And so another thing that makes the False Claims Act very unique, in addition to being able to bring an action on behalf of the government, in addition to being able to recover a portion of the government's claim against the defendants, the False Claims Act also has very robust anti-retaliation provisions, and they are both broad in who they protect and broad in terms of what constitutes retaliation. And so the False Claims Act was amended in 2010 to expand the group of people who are protected from retaliation. You don't have to be an employee. You could be a contractor or an agent. And it covers all types of discrimination, harassment, or any change in the terms or conditions of your employment because of lawful acts you've done in furtherance of the False Claims Act. And that could be trying to stop violations, trying to investigate potential violations. The conduct that constitute what we call protected activity is very broad. And one of the reasons that the set of people that are protected against discrimination or retaliation was broadened is because in healthcare and contracting, it's not always employees who know about the fraud. And we want to protect contractors, independent agents, and all those folks from being discriminated against. And to qualify protection, for this anti-retaliation protection, though, you do have to put the employer or the contractor on notice of a potential non-compliance or otherwise let them know that you are engaged in protected activity. And you don't have to use specific words like fraud or False Claims Act. All you have to do is show that you are concerned about false claims or inappropriate claims or inappropriate information or bad conduct that impacts a government entity that's paying your employer money. And so it's very case specific, but you don't have to use special buzzwords. But you do have to show, if you litigate these cases, that that employer was on notice of protected conduct. And there's
So
a heightened.
Go ahead.
There's a heightened notice standard for employees whose job duties include investigating, reporting fraud. And so it can't be just, oh, I'm a compliance officer and this is a compliance concern. It needs to be something more than just carrying out your regular job duties. Mark, did you want to say something?
Yeah, so this is the second cause of action under the False Claims Act. And this is a cause of action added in 1986 that belongs only to the whistleblower. And so when the statute was debated in the Congress in 1986, there was great concern that the old statute did not protect the status of being a whistleblower. And so under our laws, this is one of the most powerful anti-retaliation provisions that I am aware of. And the interesting part of it is you don't even have to have filed a successful False Claims Act. If you tried to do the right thing and it failed, you may still collect under this provision. That's number one. Number two, Pam and I have been asked by a number of countries to look at new statutes that they have passed. And I must say, while they think they're some of the strongest, they're some of the weakest I've ever seen. Because, you know, and it's very interesting, I've had two kinds of calls. The older European, I don't mean this old in a bad way, but the older traditional democracies who still haven't seemed to have embraced it. But many of the post-Soviet countries have sent me drafts that are 10 times stronger than some of the other places. And I don't, you know, I'm not suited to figure out why or why not. But there is no statute currently on our books as strong as this one, if you fit into the provisions we talk about. And Pam's about to talk about what I think is the mother lode of this particular statute coming up, the last section of the statute, which we've litigated many times now.
And so just so everyone's clear, the government's claim where the employee gets, 15 to 30%, that's the government's claim. All of the recovery and the retaliation claim goes to the whistleblower. It's not shared with the government at all. And the relief, the damages provision is very broad. It entitles the whistleblower to all relief necessary to make them whole, including reinstatement, double back pay, interest on the back pay, special damages, and the special damages are more akin to emotional distress. However, unlike other kinds of emotional distress claims, you don't have to prove that you're treating with a physician to recover those special damages. And also, like the claim that you bring on behalf of the government, the whistleblower can recover attorney's fees and litigation costs in bringing the retaliation claim. And that reinstatement provision is really important because it also shows that if you're going to trial and you are seeking reinstatement, in lieu of reinstatement, you get all that back pay. So it is a very, very powerful damages provision, particularly if you think about not just an individual employee, but a contractor who's bringing this kind of a claim. Their damages from the time of the retaliation to the time their claim is resolved could be very substantial and in the millions of dollars. Next slide, please.
So let me put a bit of a fine point on that. So I had a case years ago against one of the largest corporations in America. And my client, it was discovered that he was the whistleblower. And so I got contacted by their outside counsel, a very good law firm, and they had pretty much done a internal investigation and concluded that my client was the whistleblower. And so I cited this provision. There had been no cases under that provision at the time, back in the 1980s. And so I negotiated a situation where he left the company for 3 years while we were finishing the case. He received all his benefits during the 3 years, right down to the days off at Christmas. He received his normal raises that he would have gotten if he had stayed there. It's funny because his colleagues didn't know what happened to him. They thought he was in the American Witness Protection Program. And when he finally became public and it was on the front page of the Wall Street Journal, everybody said, well, we wondered what happened to him. But because of this particular provision, we were able to protect him from retaliation, which before this time, you would have had to a hodgepodge of what I would call common law remedies, not statutory, which never worked very well. And by the time you got to the point of protecting the whistleblower, he or she would have had a lot of bad things happen. So it really is in the first 15 or 20 years, a somewhat underrated provision. I think now it's becoming a very important provision. Pam and I just recently settled a case where a very significant settlement, it was a sealed settlement, a very significant settlement happened as a result of some clients of ours who had blown the whistle. The government resolved their cases years ago, but they had been fired rather nastily, and we were able to redress those claims rather fully. So it's a very important provision. I think next we're going to, excuse me, give you a bit of a nutshell of how the process actually works.
Okay, so the first step in all this is the filing of a complaint, which anyone who does litigation understands that starts the lawsuit. But it actually doesn't start our work. That's the beginning of the end of the first phase, because oftentimes whistleblowers come to us and they know about a discrete kind of conduct, and we need to wrap around that conduct the framework of what is a False Claims Act complaint. Our jurisprudence requires us to plead fraud with particularity, so it's not the normal kind of lawsuit that a lot of people are used to, where you just make broad allegations and then you spend the litigation proving them. You actually have to prove the fraud within your complaint. And basically the seal period, the government is conducting an investigation in step 2, really just to prove what you've already told them. It's not a time for adding claims, really. It's a time for you proving your bona fides to the government, that when they get in and they subpoena documents and they talk to witnesses, yes, the whistleblower had the fraud scheme right. And that second period can be quite lengthy. It could be anywhere. The fastest case we had resolved was 2 years under seal. The longest case I've worked on was 8 years under seal. And, you know, those cases run the gamut. And the seal period is extended, that federal investigation. There's actually a judge that's involved in monitoring that seal and making sure that the government's really advancing their case during the seal period. And we don't want everyone on this call to think that the defendant never learns about the case. Oftentimes, the government partially unseals the case, perhaps redacting our relators' names and identifying information just to tell the defendants the strength of the allegations against them. Step 3 is that all-important intervention or declination decision. Are they going to intervene and take over the case and resolve the case, or are they going to decline and allow the whistleblower and their private counsel to proceed on their own? If the case is successful, the defendant resolves the allegations. Oftentimes it's calculated as 2 times damages instead of 3 times, which is what the defendant would pay if the case went to trial. And a judgment could be entered against the defendant, but oftentimes these are settlements where there's no admission of liability, but the payment of tens or even hundreds of millions of dollars. And so once you get to the point where the relator is a successful relator, the case has gone to trial or it's settled out of court, a successful relator is entitled to 15 to 30% of the recovery, depending on whether the government intervened. And sometimes it's a mishmash. The government intervenes in one claim, but not another, but they're both resolved. And then it's the lawyer's time to now argue with the government where between the 15 to 30% should the relator award fall. And that's when you get involved in, or we get involved in presenting to the government the value of the relator. And remember, a minute ago, I told you that the complaint is very important. The strength of that complaint also many times dictates the award, because to the extent the relator's particular allegations were borne out in the investigation, that would lead to a higher recovery in that 15 to 30% continuum. And again, the relator would also make a claim for their legal fees and costs.
I'd like to add a couple of things to the excellent and much abbreviated nutshell. For those of my colleagues who are criminal lawyers, and I was a prosecutor and practiced white collar criminal work as well. This is a civil statute. when you listen to it, you would think it's a criminal statute. And many of the early decisions by federal judges would often make that mistake, but it's a civil statute. What we haven't talked about is False Claims Act whistleblower cases very often trigger criminal investigations that are follow-on. And to put it in simple terms, whistleblower files the case. When we sit down, Pam and I, somewhere in the United States or even Puerto Rico, and we sit down with a team of prosecutors and agents, oftentimes there are criminal prosecutors at that table trying to figure out whether there's a criminal case and a civil case. So all of the discussions we've had have only talked about the civil. And when I showed you that number with $72 billion, that doesn't include any criminal recoveries that have come as a result, direct result of the statute. So that's just something to keep in mind. Number two, the False Claims Act has very powerful tools that are not in many other statutes that allow for prosecutors to obtain knowledge while the case is under seal. And there's a whole section in the law which allows for very powerful subpoenas, which would be similar to grand jury subpoenas in the American system. There is an unusual provision that allows for depositions to be taken of potential defendants and witnesses without defense counsel being allowed to really participate in that, unheard of in most American laws, and the ability to ask questions while the case is under seal that have to be certified by an individual that they're accurate. And so that's a part of the statute that is extremely powerful. Pam mentioned what the complaints look like, and they are very complicated and technical, but if you go to, I think, page 3 of the presentation on our website, falseclaimsact.com, you'll see what some of the complaints look like. So if you have a curiosity about what they are, you can actually see what they look like, and some of them have both causes of action in them, all right? So I just wanted to kind of, for those of you who would not be familiar with it, civil, not criminal, although the sanctions are very much like a criminal statute, with the exception that no one can go to jail. However, if you're a defense contractor and you are billing the United States government for building ships or Trident submarines or anything else, if you are a hospital, if you are a laboratory, and you violate this statute and you're found to have violated the statute, you may be thrown out, you may be excluded, you may be precluded from ever submitting another bill to the United States again. Many people refer to that as the death knell, because if you can't submit bills to the largest payer in the world, in some parts of the world, that's a problem, okay? So I wanted everybody to kind of get a full understanding of that program. Now,
And just to follow up on what
Yeah.
Marc said, you know, the consequences, because we also have State False Claims Act, the consequences in the particular state in which either a domestic or a foreign actor is billing the government are very important. Some states, if you have even $1 in False Claims Act judgments against you, you are automatically barred from ever contracting with that state again. And so it's not just the federal government you need to watch out for in terms of consequences of liability under the False Claims Act. There are also state False Claims Act, which, depending on the kind of work that a domestic or a foreign corporation is involved in, could be very far-reaching.
so we've talked a little bit about the success of the Federal False Claims Act. We've talked about the amount of money and how it has worked. We're now going to transition a bit to our next slide to the fact that many in Congress decided, with the backing of a number of interesting groups in the American society, and this is kind of an interesting, and I'll be 2 seconds on the psychological and sociological. The Congress and the press seem to like whistleblowers a lot for different reasons. For the Congress, it was a way to close gaps that had existed in the recovery of money. For the press, it was an opportunity to get into facts that they had never known. And the press is considered many times, you know, the fourth member of our government, saw it as an opportunity to look into corruption, to look into overbilling, et cetera, et cetera. If anybody watches anywhere in the world, 60 Minutes, 60 Minutes loves whistleblowers. If you were to punch in their whistleblower, they were the first one ever to do one. And it's very interesting. So as a result of the success of those, other whistleblower programs have been passed over the years. And we're only going to deal with the ones who have been, I think, successful and the ones that I think would be of interest to your audience. But we're now going to refer to these as reward programs, and I'll explain why. Pam and I have been discussing a statute, a law, meaning that a whistleblower can take advantage of language that was provided by the United States Congress that gives that person, he or she, statutory rights in a court of law in any federal court in the United States. And if they meet the requirements of the statute, they can walk into court, and for the lawyers on this world, they would have standing. Everyone understand, they have standing now. The reward programs are different, and we're going to talk about them now. And at first, frankly, they were afterthoughts. They were programs that people didn't understand. But now they've gotten to the point where I've now referred to them as the Big Four. I just came up with that for this. It doesn't mean that's how anybody else refers to them. But the next slide, if you will discuss in some detail the Big Four reward programs. I told you before that the IRS, the internal regulatory, our taxing entity, much beloved by Americans, needed to have a mechanism. And there was no mechanism in the False Claims Act because it was exempted out of the 1986 bill. So members of Congress said, you know, we're always losing money. We don't understand what's going on. And we want to have an IRS whistleblower program. And so, and lo and behold, the IRS was the first of the programs to be passed. And it is a tip, a reward program. Unlike what Pam and I have been discussing, where you file a complaint, you go in, you basically take a submission and you put your best submission together and you meet the criteria of the IRS and you send it into the IRS, which many of us think in the past have been a complete black hole. And if they decide that they like your allegation, they may give you a reward. Okay, so that's basically how the IRS program has worked. I personally believe that it still needs a lot of help. I think members of Congress are still not happy with it, but it exists. The next program passed was by the Securities and Exchange Commission, which in America is responsible for a large swath of publicly traded companies who are involved in security transactions. If you open up the Wall Street Journal and you look at all the American companies, they don't even have to be American companies. Many of them are jointly owned. You look there, and to the extent that there are violations of the security and exchange laws, or a law that many on this podcast know better than I do, the Foreign Corrupt Practices Act, which a way in which this takes the SEC program and spreads it across the world. And the SEC program, as you see, has been a tremendous success. So we'll talk about that a little bit. A subset, and very similar, is the Commodity Exchange Act, which deals with the derivative markets of the United States. Commodity markets, oil, sugar, gas, all kinds of things. Very important, maybe not as sexy, but traded day in and day out all over the world. And so that is part of that. The last one covers the Bank Secrecy Act, very, very big in many, many countries in Europe, known to many lawyers here in this, better than I. And that program is a relatively new program, but a growing program. All right. So those are what I call the big four. There are other programs that, frankly, I don't think have been as successful and don't have the same ability to do that. But let's go through now some of the processes that are the same but different from the False Claims Act. Remember, False Claims Act, a statute standing under a statute, okay? Pam and I, in many respects, find these to be easier because all the work that we've described, you don't have to do. You have to do one really good submission.
So next slide, please.
Yes, I'm sorry.
Okay. Yeah, so the process is much abbreviated, and there's a benefit and a detriment to that. So the very general process is that you have to collect information and create a narrative that is a tip to the agency's whistleblower program. There are some technical requirements for these programs, but they're not the robust kind of pleading requirements that a court's going to be coming in and weighing in on under the False Claims Act. And so the tip to the agency gets submitted, and it's essentially a bit of a black hole. There's not the statutory right to feedback and to weigh in and to agree or not agree with an extension of the seal. The investigative arm of the agency to which you are submitting it determines whether or not, A, they're going to even pursue the tip, and B, how robustly they're going to seek a recovery. And if the tip leads to recovery, the whistleblower in shadowing the False Claims Act could get up to 30% of the recovery, with the minimum being set at 10 or 15%. And Marc can talk a bit about the eligibility and the protections of these reward programs.
So the protections are good. They're not as strong as the False Claims Act, but many of these programs have something that does not exist in the federal False Claims Act. Anonymity. You may never be known, ever, that you were the whistleblower. If you take a look again at the Wall Street Journal or the New York Times or the London Times, you'll see in the business section, 2 whistleblowers were given $31 million under the SEC, but you don't know who they are. And even if those whistleblowers complain and try and take advantage of the court system, no one identifies who those people are. So it is really, really very interesting and very different. And these these big 4 reward programs are gaining a lot of notoriety internationally. If I go to the next slide, and to give you a sense, I mean, a sense that you know better than I was visiting a couple of countries this summer. I had the good fortune to visit Scotland, for example, and I walked around Scotland. Of course, sometimes I walk around in a different way that other tourists do. And I noticed that there were hundreds of American companies that were either owned by Americans in Scotland or just owned by Americans. And I decided to do a little research, and I found out that in a relatively small country of maybe 5 million people, there were 55 major American countries in Scotland. I didn't say I did anything bad in Scotland or filed anything, but I was quite taken back by how, and that appears everywhere in the world. And so the foreign whistleblowers outside of the United States have been taking advantage of what I call the reward programs in greater because, frankly, it's easier for them to do that. We get a lot of interesting calls, sometimes in the middle of the night, from various lawyers who are looking, who have a client or looking to look into that. Many of these programs a little less with the IRS, a little bit more with the other three programs because they deal always with almost international areas. Let's take a standard situation with the SEC. You have a publicly traded company on the New York Stock Exchange, and you get an insider who decides that somehow the stock prices are being manipulated as a result of some type of massive fraud, or the books and records of that company are being tainted so that when shareholders are buying shares of stock, they don't know though. Those are the kinds of cases that are getting a lot of attention. The other interesting area is that the rest of the world, and to a lesser degree, but more, the rest of the world are passing very powerful anti-corruption laws for a whole variety of reasons. And some of those anti-corruption laws then interface with some of the American laws directly, because the banking laws and the security laws all find a joint home, if you will, in those statutes. And to give you just kind of one example that I alluded to, and this is a client of ours, Michael Epps, this is a public matter. We in the United States were still in Afghanistan. We were pumping billions of dollars into Afghanistan. Frankly, even though we had been there many years, it was a relatively foreign theater for us, removed from many American companies. And many of the people who were manning those places were not American citizens. And so Michael Epps was a German citizen who actually was living at the time in the Philippines. He contacted us, and he had been a member of an American and a German company, and that company was a gigantic company who, as we made it, supplied bread and water to our troops, except that the bread was at 90 times what it should cost in the United States, and the water was at about 200 times, and that was our bread and water case. And that person was able, we kept flying him in from the United States. We had a team of both federal civil prosecutors and criminal prosecutors, and that company was prosecuted both civilly and criminally. And that was one of the growing example of people, expatriates, actually had only been American citizen maybe for 2 years, but had taken advantage of that area.
And just to add something, you don't have to pick and choose. There are instances in which we would file a False Claims Act case under seal for false submissions to the government, and then an SEC filing because that fraud could potentially impact share price, and the impact would also cover revenues for that company that are not related to money they get from the United States government. So these reward programs can oftentimes be an overlay to an underlying False Claims Act case that's filed under seal.
Yeah, that's an excellent point. And that's something, as our practice has evolved, we are doing more and more of, where as we are triaging cases, we do have first to file requirements under the Federal False Claims Act. So if we see that there's a Federal False Claims Act violation, we get that done and under seal. But if we see that there are violations of the big four, securities, commodities, IRS, others, then we will contact those agencies who have independent power and have independent abilities to find different damages that the federal government under the False Claims Act, because a violation of the securities or the tax laws are different than what would be found under. So as we'll talk about in the next slide, you will see, I tried to get, and this has already increased as I was preparing the slides for today. 2 of the 3 largest whistleblower awards in history have gone to involve foreign defendants and misconduct occurring abroad. You know, we truly are a united world, even though sometimes we feel we aren't. And although at times the news underscores our differences day in and day out, we're a completely integrated world that people don't know. The Ericsson company, just to give you an example, in December of 2019, $1 billion to resolve both criminal and civil actions of the FCPA, which went over 5 different countries. That does not include fines that they paid to individual countries that they did business in also. Deutsche Bank, I don't know much about Deutsche Bank other than they seem to get hit a lot. So anybody here who's looking for compliance work, that would be where I would be looking for. But Deutsche Bank seems to be a frequent flyer. And so these will give you some idea of where the trends are going. And frankly, even if the Federal False Claims Act were obliterated tomorrow as a result of a Supreme Court decision, I don't think that the rest of the reward programs would go anywhere because frankly, they're too successful. And at a time where, to be honest with you, our Congress is spending more money than they're taking in, I can't imagine anybody is going to try and get rid of that. The next slide will give you a thumbnail view of how these programs have progressed. And I think they're quite impressive. I mean, I frankly, discounted some of these programs early on. There is a provision in their enabling statute when they were set up for the various programs to report each year to the Congress how they're doing, and for the Congress to decide whether they want to change the programs. The IRS has been under the greatest scrutiny because they have been behind. The Congress in the last appropriations bill has pumped in more money into investigations for some of the IRS programs. And I think that I actually read an article yesterday that the SEC program has become so successful that they are receiving so many tips that they don't even know what to do with all of the tips. Now, the transparency, as Pam mentioned, is not there yet on any of these programs. We don't know what happens to the programs. When you submit a reward program to the Big Four, unlike the False Claims Act, where we can constantly be involved in it and or co-litigating and or litigating, you receive a number and it'll say, we received your application and don't basically call us, we'll call you. And every once in a while you'll get something and maybe you'll get a check and maybe you won't know how it came about. And I think that's a flaw, but I'm not in the Congress. I think that the programs could be tweaked a bit, perhaps, to make them a little bit more successful. But that's where they are now. As I mentioned earlier, as other laws are passed, oftentimes you see amendments to those bills to attempt to add whistleblower provisions, okay? Because they're a successful way to do that. Now, whistleblowing in the American press often gets confused with what we as lawyers have been discussing, which are legal avenues. As I mentioned in my first WOLEP presentation, I think whistleblowing is a generic term for many things that happen, at least in our country, and in other countries, it's a pejorative term. It's not something that people like to hear about. But we've talked about whistleblowing that is either part of a statutory framework or a reward framework or a protective framework, because some of these statutes have protections that don't exist anywhere else in the world. And so, Pam and I, a number of years ago, had a very spirited conversation with a number of colleagues, and we were in Paris speaking at a conference, and we had people from all over the world, and the topic of whistleblowing came up. And 6 of the people at the table thought it was horrible, and we would never do it, and they're rats, and we were laughing because like it was what we do a day and night. But none of my European colleagues or UK colleagues, seemed to embrace it. But most of them realized that that things were moving toward that in Europe for a lot of other reasons. But that's where we are.
And you might just look at this graph for a minute and see, look, in 2021, there's an inverse relationship. The SEC whistleblower rewards went up and the FCA went down. You really can't tie that to any particular event, COVID or anything else, because that's the reward, right? That is years in the making of issuing a reward. And Mark didn't say this, but in America, we don't have better rewards under Republican presidents or Democratic presidents. Whoever the president is doesn't really seem to impact whether whistleblowers are being rewarded or not.
Yeah, there's almost been an apolitical involvement, and the long history of the modern statute has been interesting in that I think when it was first passed, the Department of Justice, which is the primary implementer, even though some had lobbied for it, really didn't like it because it gave private individuals the ability to take control, if you will, of cases. I think they've embraced it now because they realize that only through insiders, the cases we work on are very complicated. And without an insider, you'd have no idea where things were going on. And sometimes they're even too complicated to the branches of government we bring it to, because either they're not ready to hear it or not. But there is an avenue that at least exists. Not always perfect, but it is an avenue that exists.
Next slide, please. And so, American whistleblowing, in a nutshell, the model has been around in its current form since 1986, but really robustly amended in 2010. The programs have netted billions of dollars back to the U.S. Treasury and hundreds of millions of dollars in monetary incentives to whistleblowers or insiders with knowledge. And so the model has been so successful that the United States False Claims Act whistleblowing program has been co-opted in a number of other programs, the SEC, the IRS, etc. None of these programs require the whistleblower to be an American citizen. One of the key features in the FCA or False Claims Act realm, and some of the others, are the anti-retaliation provisions. Interesting that one of the requirements for publicly traded companies is that employers in publicly traded companies cannot put any kind of a gag on their employees or prohibit them from making any kind of complaints to the Securities and Exchange Commission. It's specifically protected in the Sarbanes-Oxley Act. And so these non-FCA or non-False Claims Act anti-retaliation provisions and anonymity protections in some ways afford more protection under those non-FCA laws than you would get under the False Claims Act. The trade-off there, as we've already discussed, is that you really don't have as many rights to participate in the process in those reward programs. Mark wants to talk about outside awards and growth.
Yeah, so my last point, and I'll turn it over to our host. One question I always get, and for those of you who are thinking about it, if I represent a whistleblower and they recover a fair amount of money, that recovery is fully taxed by the United States. So the United States actually gets a second windfall, and that they get fully taxed. Number two, Pam's point is, I want to expand on it. In most American companies who deal with the United States government in some significant manner, a hospital, a pharmaceutical company, a military contractor, not only do they have to have protections and hotlines for potential whistleblowers, something that shocked some of my colleagues when I was in Europe. But they must provide that individual with training on the False Claims Act. So sometimes we're called in for corporations to train them because they have to allow their employees to understand, as a check and balance, what should happen if they do face corruption within the company. I don't know whether that exists all the way around the world, but I know in the United States, if you're dealing with significant billings or even insignificant billings to the federal government, that's a requirement. So that is kind of where we are in our formal comments, and then I'll take whatever questions or anyone has, and I hope it was enjoyable.
Indeed, it was. Thank you so much to Marc and Pamela for their presentation. I'm sure that everyone found it very insightful and helpful for everyone's practice and their professional development. So again, thank you, Pamela and Marc. It was, as always, a pleasure to welcome you amongst us. And I think now we can begin our Q&A session, for which we invite everyone who is with us to address questions to our esteemed speakers. So during your presentation, we also chatted a bit with our attendees, and I have a bit of background info about one of our guests. We welcome Mr. Kamil Bechta from Poland. He complimented you. He said that it was a very interesting lecture, especially for him who graduated from the American Law Program School in Poland. So if Kamil...
Dziękuję ci bardzo.
Kamil is still with us. I think we'd be delighted to have a question from him.
So it's very interesting. I have been contacted by some Polish lawyers, and there are two areas we alluded to. So in addition to the False Claims Act, the anti-kickback statute, which we didn't really have time to get into today, is probably one of the most powerful statutes in addition to or together with the False Claims Act. And that really deals with bribery, corruption, those kinds of things. And I've had some very interesting exchanges with members in Estonia and in Poland, where they have been doing some interesting things to beef up some of their anti-corruption statutes. We've had, Pam and I have had the ability and the good fortune to speak with some French lawyers who have been progressing very nicely on their anti-kickback version of the anti-kickback statute. And it's interesting, I find, and that's one of the reasons I wanted to become more active, I find international law interesting because I'm always looking to find the same kernel. We're all lawyers, we're all trained in a very similar matter, and I'm always looking to see how people approach it. So thank you for comments from Poland, and I have enjoyed some of the chats I've had with the Polish lawyers, and we'll see what kind of statutes are going forward.
Thank you, Marc and Pamela. So I have to be a bit indiscreet now and
Okay.
Let's say expose one of my friends who's for the moment is an outsider in relation to WOLEP, in relation to our network. So welcome Claudiu. He's a friend of mine, a lawyer in Romania, and I know he has a keen interest in this topic because he deals with whistleblowing. So if Claudiu hears us, I'd like to welcome him, and maybe you have a question for our speakers.
Thank you very much. Thank you very much, Todor, for your kind introduction. Indeed, it's been very interesting to see some of the key points on the whistleblowing subject, and as presented by your esteemed guests, our esteemed speakers. Indeed, it's very interesting to see how whistleblowing is functioning in the oldest democracy in the world, and to see what are the differences between what's happening currently in the EU with the whistleblowing directive and how it's being implemented, both at a state level in every EU member state and also in our local jurisdiction here in Romania. There are clearly significant differences. First of which, the first difference is that of being rewarded for a complaint that a whistleblower makes, which is, at least at this point, not envisaged by the local legislation. There are some discussions in our parliament in this respect. There have been some projects, some law proposals by some members of the parliament in this respect, which have taken as an example the provisions regarding this FCA awards between the 15 and 30% of the amount to be awarded to the whistleblower, but they are still at a discussion level, so there's not very much in this respect to add. Obviously, it would be interesting to co-interest the whistleblowers into being active in this respect. However, I think that as it's been mentioned before, it's more of a cultural issue, and in Europe, it's not that, I don't know, it's kind of a gray to be perceived as a whistleblower. So from this point of view, I still believe we have some time to, we still need some time to internalize the positive effects on this topic. But nevertheless, thank you very much for the presentation. It's been insightful, and looking forward to any future presentations in this respect.
So Claudio, I appreciate that. And the one word that I have heard is the cultural word. And so I love to debate in a nice way our colleagues, and so the cultural issue has been an impediment. The other area that Pam and I have found very interesting, when we are asked by our colleagues to look at legislation from another country, which we have had the good fortune to do, and comment, we find that the cultural tilt is that many times the laws or the potential laws are skewed to the prosecution of the whistleblower. So if the person comes forward and doesn't tell the truth or doesn't do something, the whistleblower ends up being prosecuted. And so I tried to explain to some of my colleagues who, why would anyone want to come forward and get prosecuted, have no protections? And, we got into some principled but spirited debates on that. So I do enjoy it. And Claudio, I appreciate your comments on that.
And just to follow up, one of the big differences, Claudia, in the EU provision is that companies have to have internal reporting. You have to do your internal reporting under the EU framework in a very particular way. You have to wait 6 months after you made the internal report to make external reports. Those requirements are not there under our statute. And while many of our whistleblowers did report internally and tried to fix things internally, it's not a requirement under our statute. And that's one of the biggest differences in the framework between the EU and the United States, this obligatory internal reporting. It makes the whistleblowers almost at a disadvantage, right? Because if you do your internal reporting, it's obvious, it doesn't have to be anonymous. It could be a named reporting program. And it really, I would think, would make people less likely to report because they're afraid, you know, if their tip doesn't work out, then somehow their job would be at risk. And so the robust whistleblower protection programs, either in the IRS or the SEC or the FCA in the United States, are really super important to protect people who want to make those reports. And it's going to be interesting to see the different frameworks the different EU countries develop in terms of having these robust internal reporting mechanisms, and whether they really stem the tide of fraud or whether they're just really a step on the way to making an external report.
Just to give you some clarity on what's happening in Romania in this respect, and it hasn't been yet marketed as a true tool for people to participate in creating a stronger market. The law came into force in December last year, and the provisions pertaining to the enactment of a channel, of a whistleblowing channel in companies and in public authorities was due to be established for companies, for example, which have more than 250 employees immediately after the law came into force. But for companies which are the vast majorities of companies acting locally, having between 50 and 250 employees, it is due to be mandatory by the 17th of December this year. So it's still under development. We will see, most likely we will be able to draw some conclusions in 2026 maybe, of how well this has been transposed in local legislation, and if we had any positive effects in this respect. But until then, I think it's everybody's guess.
So the interesting point is that for the first time in the last year, in talking with lawyers outside the United States who sought my counsel, a very sophisticated lawyer from Switzerland, and I was very, very impressed. He had concluded, and obviously there's a lot going on in Switzerland with American companies, but he had surveyed the European whistleblowing laws and had decided that he would be putting his client at risk, who was a Swiss citizen, and was seeking to take advantage of the American laws, which I thought was I was very impressed. Number two, in talking with my colleagues outside the United States, who are, I would say, walking, not running, not only is there the cultural issue, but I think when I talk to them, there's some resentment about the international community forcing upon certain countries anti-corruption laws, anti-whistleblower. I could be wrong, maybe, and everybody on this call is much more sophisticated. I see Cosmo is on the phone, and I had a nice conversation with him. So, it does take some experimentation. We didn't talk about how the American statute tries to keep in check a whistleblower. So if a whistleblower comes forward and he or she is part of the crime, that whistleblower can be and is prosecuted. And so that occurs. If that whistleblower is a little bit part of the crime, that whistleblower may get less of a reward than normal. So there are gradations in the statute we didn't really have a chance to talk to, and those gradations might be things that my colleagues on this program might want to look at. They are built into the statute. So, we've tried to reach a balance. Many people in the United States on the defense community would say that there is no balance. Many people that do our work say that needs more protection. And all I can tell you is no matter who you speak to, the fact that it's been successful has bred its own success. So that's why you see the progeny, if I call, the other programs being added. And I think that's going to continue. One last interesting point, maybe at least from a legal point of view, the United States Supreme Court, which didn't touch the statute, now is taking a lot of interest in the statute. And there are a lot of reasons there could be for that. But so it used to be that you wouldn't see the Supreme Court weigh in on a whistleblower case for 10, 20 years. Now you'll see one a year, sometimes twice a year. I'm not sure where that's going, one way or the other, but that's been interesting for American lawyers who are following the jurisprudence under the statute. Having said that, no matter what the Congress has done to the federal statute or what the courts have done to the federal statute, it hasn't impacted so far the strengthening of what I call the reward programs. Because for the Congress and for the Treasury, you know, the security and exchange area is so complicated. And to be able to get, I read a statistic, I don't know if it's true, 1,400 tips this year into the SEC. I don't know what the level of those tips are. That's a lot of tips, all right? And for those of you who are defending companies all over the United States, United Kingdom, all over the world, and you're involved in hotlines, which we have here, and I'm sure you have there, I've never heard anybody that gets those kind of tips on a corporate hotline, all right? They just don't. Now, maybe they don't want to call into a corporate hotline, or maybe they don't believe that it's going to be protected. But, you know, that's how I kind of calibrate in my own anecdotal way how things are going. So, but I do enjoy some of the comments. They're really to me, very, very interesting.
Thank you for your answers. To our guests' questions. And we have another question from Mr. Camil Bechta, whom I mentioned earlier. So his question, for which we thank him, is for both of you. What are the perspectives of whistleblowing procedures in connection to new technologies, especially or in particular artificial intelligence?
That's an interesting question. Pam, do you want to try that?
Sure. So I don't know that there are any special protections or procedures connected to artificial intelligence. We have not run into that yet per se, because fraud is committed by people. And we represent the people who know about the people who are committing the fraud. I haven't heard of a case where artificial intelligence played any kind of a prominent role. I know that we are focused in the United States on combating fraud in the cybersecurity space. And to the extent that there would be a person who initiates some AI encroachment into that space and impacts sort of cybersecurity or company operations, I would tend to think that's the only place that AI would really play a role. You know, I think that's something, because AI is just making its way into industry on a large scale right now. I would think that's something that we're going to see, you know, maybe 5-10 years down the road. And remember, the cases that we're seeing now is conduct that often occurred several years ago. So there's always a delay between a report, an investigation, and public knowledge of a case. And so I expect those sort of AI impact cases to be coming and become part of the public forum sometime in the next several years.
Let me just highlight what Pam just said, because to me, it's fascinating, having done this now for many years. There's always a lag between the whistleblowing and the amount. Let me give you an example. And this is something that touched everybody. Massive amount of money in COVID fraud funds in the United States. Money was going out faster than we could protect it. Now, Pam and I are getting all kinds of whistleblowers coming forward with COVID fraud schemes, okay? For better or worse, we're running out of weapons to send to the rest of the world. We're literally got our defense contractors going night and day. I'm not saying we're proud of that, but that's what's happening. We're going to see a rash of cases coming forward, right? Because they're building weapons faster than they can do it. To me, that is the kind of the check and balance that whistleblowers bring. It's never immediate, okay? But there is always a lag. I'm sure there's going to be artificial intelligence cases, you know, because that's all we're talking about here in the United States, but we haven't seen them yet. Okay, so there's always a lag behind there, and that's just the way things are.
Thank you, Marc and Pamela. A very interesting topic raised by our friend and colleague from Poland, Mr. Kamil Bechta. And I'm sure that in the months and years to come, like you've said, AI will play a very important role in many, many parts of society, law included. So I'd like to take the occasion, if there are no other questions from our attendees, to thank you for this wonderful presentation, for your effort, and for your team's involvement in this, in making this webinar a success. So once again, thank you so much, and I will hand over to Adelina for her final remarks. Thank you.
Thank you.
Nie ma za co.
Thank you, Theodore. I'd also like to thank Marc and Pamela for this very informative and insightful presentation. I think the information that you provided has enriched our understanding of the American Whistleblowers Programs. So thank you so much. It was a great presentation. And we are already looking forward to future events and the opportunity to delve into more engaging discussions on this topic or on other topics. We also encourage our attendees to take the initiative in hosting future webinars. So if you have a legal topic that you are passionate about and believe would be of interest to our community, we invite you to reach out and take the lead in organizing such a webinar. Thank you.
Thank you all.
Thank you very much. Have a good day. Rest of your day or evening, actually, where you are.
Have a good day.
Thank you.
Thank you.
Bye.
Thank you.
Bye-bye.
Bye.
Thank you. Bye-bye.
Bye now.
Bye.
Bye-bye. Thank you.